Here is a constitutional law hypothetical that focuses our attention on the First Amendment. This is about as complicated a First Amendment question as you're likely to see, and it's an enormously instructive one. As always, we start off by having a look at the call of the question. It reads, in the prosecution of Dan, what defenses should Dan assert under the United States Constitution to charges of 1. Contempt of the ex parte order, 2. Trespass, and 3. Violation of the statute, and how should they be decided? Discuss. Well, on the face of it, it appears to be a criminal law and procedure question, and so our mind might turn to the checklist of criminal procedure objections, the 4th, 5th, 6th Amendments to the United States Constitution. But as we get into this fact pattern, from the very first paragraph, it becomes evident that, one way or another, it's going to be a First Amendment question. In paragraph 1, we learn about a state-owned office building, and we see that there are a number of provisions in this first paragraph that deal with speech. We've got advertising regulations, and we've got protest regulations. Clearly, this is going to constitute state action because the state owns the building. In paragraph 2, we meet one of the occupants of this office building, a tobacco shop. Then, in paragraph 3, we find out about competing protests. There's only one protest zone in the building, and it's offered on a first-come, first-served basis. The first group to come in this case is a group of anti-nuclear protesters. So the clean air people are left out. They choose to protest at other locations within the mall, and they are escorted off the premises by the local constabulary. In paragraph 4, we find out about the ex parte order, which is the subject of the call of the question number 1 below. The ex parte order was obtained ordering the people in the clean air protest group to stick to the standard location for protests. There's nothing in this fact pattern that suggests that the ex parte order was unlawfully obtained. There's nothing wrong with this ex parte order, at least as far as we can tell from the beginning of the paragraph. So, with regard to any possible violations of the contempt order, it would seem evident that the collateral bar rule would apply. So even if the underlying restrictions were found to be a violation of the Constitution, there's nothing unconstitutional about the ex parte order, and the collateral bar rule will stop a defendant from talking about the underlying dispute when we've got a lawful court order in place. So it looks as if the quick answer to the first question about violating the ex parte order is there's not going to be any valid defenses unless something remarkable happens later in the paragraph. Later on in the paragraph, we go looking for something extraordinary and we never find it. So it looks as if the ex parte order is valid, and it looks as if any violation of that order is going to be subject to criminal prosecution without a constitutional defense. So at the end of this paragraph, we find out that the clean air people show up first the next time. At the time of their arrival, Dan receives notice of the ex parte order and apparently as a reaction to the ex parte order chooses to violate it. And we find him going in front of the tobacconist with the sign that gives rise to the violation of the 3rd statute. We learn about the criminal charges in the last paragraph. We see that there is a violation allegedly of the ex parte order, trespass, and a violation of an obscenity statute. Then we get the call of the question once again, and we see that this is about as complicated and involved a First Amendment problem as you're likely to see. At the same time, this is a very standard First Amendment problem. There's nothing in this question which is really remarkable, but there's a lot to it. So we've got to organize carefully, and we've got to answer with specific regard to connecting the facts and the law. So, what are Dan's defenses for violating charges of contempt of the ex parte order? Well, thinking about the First Amendment, since that's obviously what this question is about, we would indicate that he would argue that the ex parte order is facially void, that it is such an unconstitutional violation of his right to free speech that he has the right to ignore it. Sadly for him, it looks as if the ex parte order is valid on its face, and he should just take the time to go contest it. If it turns out that his rights have been violated, the ex parte order will be overturned, and he'll be able to continue his protests just the way he wants to. But he's got to respect the judicial process more than he has. He also might argue that he had no time to appeal the ex parte order. But again, time was not of the essence in terms of his presenting his message. The public is still going to have concerns about clean air after a few additional days lapse. There's no great emergency about the dispute or about the message that makes timeliness a particular concern. So it looks as if the collateral bar rule clearly applies to this fact situation. And by the way, the collateral bar rule is not uncommonly tested, although its name is not as frequently used as it might be. Still, the fact that the ex parte order was lawfully obtained, that there's nothing fishy about the process through which it was obtained, the defendant's ignoring the order isn't something we can defend. He's guilty of violating the ex parte order. Next, we turn to the criminal trespass charge. And here again, it might be a little tempting to go into the area of criminal law, but we're really being asked about defenses, and it's clear what happened. He received notice of the ex parte order. He chose to go to a part of the mall where protests are not permitted, and he engaged in his protest. So we've got the state-owned office building being good enough to constitute state action, and it looks as if he is being prosecuted not because of the content of his message, but because he violated the time, place, and manner restrictions. So we examine the time, place, and manner situation. We analyze it. We've got a designated public forum. Is there a significant government interest in regulating speech within this state-owned building? Answer, yes. Is the regulation narrowly tailored? Well, here's where the defense might have a little bit of wiggle room. The defense might argue that the ordinance ought to be structured in such a way as to have numerous locations to protest rather than just one, like, for example, the entrances and exits. It seems to me, though, that on balance, probably the regulation is narrowly tailored enough. Are there alternate means of expression? Answer, yes. And by yes, that doesn't necessarily mean an alternate location for the identical communication. But it would certainly be possible for the protesters to put flyers on vehicles. It would be possible for protesters to make their viewpoints known in a number of other ways. So it seems apparent that probably the time, place, and manner restrictions are reasonable, although I will grant a colorable argument could be made that reaches the opposite conclusion. Now, if it were a content-based argument, then the state would have to satisfy strict scrutiny, and it would be on much shakier ground. However, I don't think that they have to reach that level of analysis, and even if they did, the state conceivably would be able to prevail. The bottom line, as far as I'm concerned, is the defendant is guilty of the criminal trespass charge. Now, how about the state obscenity statute? At last, the defense really has some very strong arguments to make, and here I think it likely that the defendant would not be convicted of obscenity. Here, we do have to know the law well enough to be able to call up the standard. The First Amendment defense to obscenity requires knowing the three-part test. What has this guy done? He stood in front of a tobacco shop with a protest sign that portrays a naked, dying cancer victim. Notice, the fact pattern doesn't even tell us the gender of the cancer victim. We just know that he or she is naked and dying and has a bunch of medical equipment attached to his or her body. Does that graphic depiction of nudity appeal to one's prurient interest in sex? The answer is no. There may be a tiny percentage of the population that has unconventional sexual tastes who might find it so appealing, but broadly speaking, certainly there's nothing about this message that appeals to a prurient interest in sex. Is it patently offensive? Well, I'm sure that by its nature, many people would take offense to this graphic depiction, but it is not a patently offensive sexual depiction, so probably the state would be unable to meet this element of the obscenity test either. Does this ugly portrayal constitute something entirely lacking in redeeming social value? Answer, of course not. This is a very persuasive and important message about a deadly disease that is typically often caused by smoking. So certainly the message is a harsh but not obscene confrontation against cigarette smoking. So almost certainly this defendant will be acquitted of the obscenity charge. The prosecution will have to content itself with obtaining convictions for criminal trespass and for violation of the ex parte statute, or the ex parte order. So, we've just reviewed a fact pattern that is almost generic in its terms. You will see many practice questions strikingly similar to this one in your work. And that's why I encourage you to do as high a volume of practice as you can find the time for. You'll learn much more about the details of the law by studying how it is tested. And to the extent you learn little nuggets of law, I encourage you to annotate your outline with those details.